sometimes viewed controversial subjects of concurrent delay. Today's format will entail us firstly going back to basics and revisit why an EOT is necessary, i.e. an extension of time, what makes a successful extension of time claim, and what are the common and sometimes tactical grounds used for rejection by an employer. We will then move on to concurrent delay itself and discuss various approaches to it under both UK law and the approaches under UAE law. We will then give our own tips on how best to deal with concurrent delay. Finally, next, I will introduce my fellow panelists. To my immediate left is Paul Thornton. Paul is a delay and disruption expert with over 20 years of experience in the construction industry and has been based in the Middle East since 2007. Paul has given oral testimony in arbitral proceedings and has provided expert witness assistance on several delay and disruption matters in various jurisdictions in the Middle East as well as the UK. He has a master's degree from Imperial College London and King's College London. He has been widely involved in claim management and has produced and reviewed claims concerning time awards with extensive engagement in program management, project controls, systems, and forensic delay analysis. Further to my left is Oliver Dupenois, my colleague and fellow partner and deputy head of the arbitration department of Horizons & Co. Oliver has been in the Middle East and in Dubai for 10 years, 4 of those, unfortunately, with me. I'm sorry about that. Just for a little bit of interaction here, as clues on the title, Concurrency, Truth, Effective or Myth, what we'd like to do is take a vote now on 2 particular points. So if you could put your hands up, whether you think concurrency is actually a real thing, or so first off, is concurrency true? Put your hands up. Okay. And do you think it's a myth? Okay. And the second question would be, because I've done it around the wrong way, of course, is if it is true, are costs claimable during a period of concurrency? However, what we'll do is when we come around to the end of the talk, we'll ask you to show a show of hands again and see if we've managed to, or any of you have changed your minds. Okay, right then. So to start with, before we get into the nuances of concurrent delay, we need to strip back to basics. So question to you, Oliver. Why is a contractor seeking an extension of time for completion, and how does he go about it?
Okay, so put very simply, when a contractor is delayed or is likely to be delayed and needs to shift the completion date in order to complete the works without suffering any liquidated damages, that's when he'll make an application for an EOT and try to get his time-related costs as well through the prolongation costs. It's effectively trying to put himself back in a position they would have been had the delay not occurred. It should also be noted in terms of terminology which might be relevant for later discussions. There are relevant and non-relevant events. So relevant being critical, shifting out the time for completion, and non-relevant, which don't shift out the completion date. There are also excusable, non-excusable delays. Excusable are those which are caused by unforeseeable events out of the contractor's control, and non-excusable delays arising from the product of the contractor's mistake.
So what makes an actual delay claim successful? There are 4 basic pillars that need to be demonstrated. The effect of the delay, there has to be an effect of the delay on the critical path to completion. And that's very key when we're discussing concurrency. There has to be a cause of delay. And that cause of delay has to have entitlement to claim under the contract. And then there have to be records to actually substantiate the claim, and that's where most delay claims fail because there's simply not enough records. And you'll probably hear a fair few times during the course of this seminar that records. But typically the contractor will support the OT with a delay analysis to demonstrate the delay to the critical path and measure the extent of that delay during the project.
Okay, next slide.
So you need to go to the next slide. Hopefully it's working now.
There we go.
Okay. So these are typical examples of extension of time clauses. What are your thoughts on these, Paul?
So the first one, if you read it, the most important part of this is if the contractor is or will be delayed. So typically, like in a contract, you'll see is or will be delayed. And that really permits the idea that you can forecast future delays in your delay analysis. So you might put forward something like We'll go into the methods in a bit, but something like a time impacts analysis or even an as-planned impacted analysis. These are forecasts of critical delays, and they may not be critical through mitigation or concurrency, and this may actually work quite well for contractors. So when you're agreeing a contract up front, it's actually quite useful to get this clause in there, because you can agree to actually have an extension of time. So things like the NEC3 form in the UK really is very project management based. And certainly the 2017 FIDIC form is becoming, I mean, that kind of went double the size it was. And that really meant that kind of project management form and integration into contracts is becoming more and more key. So that's where we see this will or is or will be delayed. But the law is based on facts, and forecast delay can be seen, the forecast delay can be seen as fictional. So one of the most important things when we're looking at from a delay perspective is does it actually make sense? Does the forecast critical path make sense? So in terms of the second clause here, we have the contractor shall be entitled to the OT as the engineer assesses if the contract has been delayed, which implies actual delay. And this tends to be more employer friendly, but the issue with this is it doesn't really mean that you've got project management skills in there. You actually have to have a delay that manifests. So you have to take the wait and see approach, as the SEL protocol puts it, to actually put forward the delays. So so although you get an exact answer at the end, which is what we're actually looking for, and I think there's a measured amount of certainty that you get with that, you don't get the same amount of project management. So you tend to have a different view on this. But that's the basics of the contract.
I mean, I think from our perspective, in our experience of our arbitrations, the experts do tend to actually ignore the contractual terms to some extent and actually conduct a more exacting analysis, because otherwise it can be too theoretical.
Yeah, that's exactly right.
And we'll get hammered by the opposition. So
I think also, to be fair, something we don't really need to worry too much about in this jurisdiction. As we all know, I know you mentioned a FIDIC 2017, but I think as we all know, it's not the fastest road here to adopting new contracts. So I think everybody is still very comfortable with FIDIC 4, which, as we know, came out in 1987 with 1992 amendments. It's really only, rather unhelpfully, the FIDIC first edition 1999 that is just really come into play. And I think the thing to remember is that all contracts, especially here in the UAE, are bespoke. So I think really, whilst there is nothing expressly stated in relation to concurrency in the FIDIC contracts that we use at the moment, we know that they are starting to creep in. And I think as a general rule of thumb, the more onerous the employer, the more likely you are to have a concurrency clause in your contract. And I've certainly seen it when amendments, the inevitable amendments come into the contract, and especially where extensions of time are, in fact, the root cause of an amendment being made in the contract. They're usually used by an employer to negate the extension of time that is being given, and certainly concurrency and issues of concurrency are actually expressly written into those type of amendments. So I think that's a nice segue. I'd love that word segue. I don't believe I said it. Anyway, leads us on to this next question, which does the contract stipulate delay analysis methodology, and should it? So over to you, Paul, to just go through the actual different types of methodology that can be adopted.
Very good. So one of the, I suppose the answer is the contract is the contract. So we work with it most of the time. And really those words is or will be tend to be key. So when we look at delay analysis, we look at it in terms of two ways. And this is SEL guidance, but the way the critical path is determined and the way that the delay impact is determined. So in terms of the way that the critical path is determined, when you're doing something like an as-planned impacted, what we have here is we have a baseline program, which is the viewpoint of the way that the parties have modeled the way a project will be built. And then simply they take what's known as fragnets, which are the events that are potentially, you would hope, would contain the liability only of the employer. and you would then impact that with a fragnet into sequentially into the baseline program. So you're not taking into account any progress whatsoever of what the contractor has done during the project, but you are taking into account what's quite good about it actually is where you've got something like an access delay up front that's very clear about it's a simple analysis. It doesn't take much time, and actually it allows contractors to put down the bare bones of their events, which is probably one of the most important things to communicate in the first place. So even it can be just put down as a placeholder. But it doesn't. But it's not a particularly robust technique, and it needs to be enhanced in the future. So the way that that's typically enhanced is that you then start providing in the program in the project. The planning team will typically update this baseline program with progress, and through that process, you'll see things like out of sequence works, that the way that they envisage the actual initial model that they've put forward in the baseline program has actually not been modeled, or hasn't in actual fact happened the same way. So what you'll typically do is you'll update the program with progress, maybe on a monthly basis, and you'll determine what the project team is actually saying is the critical path at any one time. So that's known as the contemporaneous way of looking at things. And the time impact analysis, the time slice analysis uses those particular markers. The as planned versus as built windows analysis uses something slightly different. It's more to do, the windows are identified by important key events that have happened in the project. So for example, power on or something along those lines, or it might be completion of the 6th floor structure in a building where you might get the takeover of other trades afterwards. So you identify these key matters within the windows analysis and then go from there. It really takes into account the historical progress and then the strategy for the future works. So moving on to the next slide. The last way of determining the critical path is to look backwards. So you look at the perspective from the end of the works, or the end of the window in the case of collapsed as built. So typically, like something like a collapsed as built, that tends to be the most pro-employer way of looking at delay. It's not often used. I've only actually done it about twice in my career. But the way that works is you collapse the events. So you first of all construct an as-built program, and the logic in the as-built program is actually different to the logic that you would have in a baseline program. And it doesn't rely on a baseline program whatsoever. It just relies on the as-built logic. So you typically put the events in, the start dates and the finish dates of the various activities, and then collapse in reverse chronological order. So you collapse from the end and go backwards. So it really is truly looking at it retrospectively all the way back. The longest path is a kind of pared down version of an as-built but for analysis. And it really relies on the analyst identifying where he feels this is where the critical path actually was on the project. And he might use things like the contemporaneous updates to inform that, but ultimately he's effectively drawing a line from the end of the project back to the start of the project, and understanding how this project has proceeded. So then we move on to how the delay has actually been determined. And as I said before, that the impact as planned, which is effectively the same as a time impact analysis, but you're just using one program instead of many. That measures the forecast impact of the completion date, and it's modeled. So the most important thing here is you're actually putting in a fragnet into the mix, which separates the liabilities. So the most important thing about this is, we talked about before about the 4 key pillars. One of the main things is dealing. You have to make sure that you're separating the employers and the contractors' liabilities and delay analysis. So quite often I see in fragnet contractors actually putting forward events that are their own liability within the fragnet. So they might there might be kind of an approval process, approval submittals and what have you. But the approvals process, when that submission time, say there's a certain amount of time allowed in the baseline program, and then they actually extend that period by a couple of months, say, and that's contained in the fragment. And that's the kind of place where actually that should be separated out, because really that's contractor's progress. It's nothing to do with the actual employer event. So that's the modeling technique. And then the retrospective looks at the observed delay to completed activities. So there's a historical impact of the delay event on the critical path during the time slice up to the data date of the particular analysis. So in terms of the retrospective, it tends to precipitate in actual delays, which is really the most important part. So these methods tend to be much more arbitration after the fact. So quite important. So yeah, I think that's the delay method.
Can I make a comment?
Yes.
Briefly, Peter.
The heading was, should the delay analysis methodology be in the contract or not? You've not answered that question yet.
Okay. Fair comment.
I think I can answer that from my perspective, Peter. My view is, in fact, that the methodology should not be actually expressed in the contract. I think it's whilst it seems like a good idea potentially at the time for clarity, I mean, I think as a lot of us know, boiling it down, and by the way, there isn't a test on what Paul just said, thank God, because I was only just about awake. Yeah, it's very, very, very good, but it is a dry subject. Yeah, it's very good. To be fair, it's very good, Paul. It all boils down, as far as I'm concerned, to retrospective and prospective analysis. If you're at the beginning of the job, to be beginning of a large project, I think, to be fair, you can only really use a prospective analysis like TIA analysis, time impact analysis. And what I've seen, Peter, predominantly is when it is expressly put into a contract, it's TIA analysis that's referred to. But of course, as you know better than I do, Peter, especially when you get to arbitrations, you're sitting as an arbitrator, 9 times out of 10, the project's finished. So actually what you want is a retrospective analysis, as planned versus as built. Then you come to the old crux of the matter, and we've all seen this argument. Yes, a TIA analysis is used at the beginning, but that doesn't actually show the full extent of the delays. And a far more accurate way of analysing and impacting those delays is by the as planned but for. Of course, you get to arbitration, and certainly the employer may well be putting his hand up saying, oh, it's a breach of contract, they should have used TIA. But actually, at the end of the day, irrespective of all these types of analysis, which are very well explained by Paul, it really does come down to common sense. And I can remember, and I'm older than I look, I'm only 25. I can remember when TIA first came out, it was all singing, all dancing. You remember, everybody thought it was the best thing since sliced bread. But actually, as time has gone by, and if you apply logic anyway, a retrospective analysis after everything has happened makes far more sense than trying to predict the future. As much as the project manager is king on the job, nobody can see what's going to happen. And I don't think that's an accurate way of analysing it. I'm sure, Peter, if you were given the choice, you yourself will always adopt the more common sense approach, no matter what the contract says. So in essence, yeah, I would not express the type of methodology in the contract.
Indeed, and the other factor, of course, is, as you will recall, first SCL protocol, there was a lot of pressure to try and get that into the contract.
Absolutely, yes, yeah.
At the end of the day, the contract is between the employer and the contractor, and the engineer or the contract administrator or whatever is meant to be entirely independent, and therefore you can't put clauses into a contract. You can't put clauses into a contract which are going to bind the way in which the contract administrator is meant to analyse delay. I think that is why you should never put it in your contract.
Yeah, no, I agree, Peter. I agree. So, gentlemen, yes.
Actually, there are a couple of things here on this. I think the fact, like, if we're looking for if only retrospective and we leave it at the end, wouldn't that be case that we're encouraging employers not to deal with the extension of time at the time or the claims at the time and leave it the wait and see approach that is non-my SCL is against. So wouldn't be fair to the contractor for an employer not to deal with it and wait until the end, until it becomes a retrospective. The second thing I want to say is there is a case law in Australia called Johanan versus CMA, where the judge adopted the prospective analysis because under the contract. It's quite very known law. He rejected the claim because of time bar, but he actually said the contract is the contract, and the contract says for a prospective analysis, and he accepted the prospective analysis.
Wow, I'd hate to be in front of that judge there. So time bars and prospective analysis adopted strictly in accordance with the contract. Okay, well, that's why you see in arbitrations, certainly in this jurisdiction, you have sensible people like Peter, who you appoint as your arbitrator to get around an issue. Mr. Mellor, how can we help? Yep. It's fine, actually. we're more than happy because we run out of time. We won't, we're going to get to the vote, so I'm more than happy.
Two things very quickly. I'm completely with you on the position you take. The more things you simplify in a contract, the more complex it gets. And as Paul will be fully aware as well, we're talking about these methodologies as if they're distinct singular methodologies. There are TIAs and there are TIAs. And I'm sure Paul's done many different ones and seen many different ones as well. And so they're not necessarily that straightforward. That's all I want to say.
No, okay. And Chris, I know you wanted to ask a question.
No, I just thought that the gentleman suggested there is an obligation to deal with delay through the life of the contract in most standard forms, and that would, be presented.
You've been looking at my slides because we're literally just about to go into that. So literally, you've segued me in. I've got to segue in again.
Only happy to help. Paul.
Yeah. Okay. Good. Okay.
I mean, from my perspective, I worked with Keith Pickvance when I was in London, and he was one of the original advocates for the first SCL protocol. But the landscape at the time, when 2001, I think, when the original SCL protocol was drafted, was very much along the lines of people didn't have programs. They literally didn't do time management properly. So one of the points about the time impact analysis and why it was so encouraged in the first protocol was because they were trying to encourage this time management that didn't really exist beforehand. So in order to incentivize that, it was put center and front of the SL protocol to say, look, this is how you're going to get a claim through at the time. And I kind of think it was time impact analysis has been scapegoated a little bit, and especially in the second protocol, where really there is a time impact analysis that falls somewhere between a time impact analysis in that protocol and the time slice analysis. There is a kind of another time impact analysis that's a bit more sophisticated. So I think Andrew, is it Andrew Mellor? Yeah.
Yes.
Yeah.
I've seen one inverted as well. This is great. The contractor slammed in delay impacts and then progress behind it, and the progress never did anything because the delay impacts drove the completions at the time, which is silly. But it's kind of like the Android Krevin scale of Morgan Wise. He had all the right notes, but he wasn't playing them in necessarily the right order.
Good stuff. Right. So, not a stilted question at all, Chris. So, Oliver, from your perspective, how do you believe contractors' extension of client time claims are dealt with by the employers and engineers in practice?
Well, I mean, certainly from our experience, the employer / the engineer would reject the EOT outright, really. It's really sort of a classic delaying tactic, kicking the can down the road. They probably, amongst other things, reject it on the basis of lack of details, which can be a valid reason. I've seen claims that are 2 pages, don't have any sort of methodology included, and it's just not too basic. It's not going to work.
Yeah.
Then you've got just a simple disagreement. They don't believe the delay events actually impact. Then the methodology used is obviously key. I mean, as we've just discussed, there's different opinions on them. So, and then lastly, obviously, you've got concurrent delay.
Well, before we get on to concurrent delay, I mean, one of my particular favourites, and always a particular subject with delays, is of course when the engineer himself is the root cause of the delay. And yet he is the person that is meant to be administering the contract and awarding extension of time. So I'm afraid when we have issues of like inadequate design or late responses to RFIs. These are clearly issues that are compensable delays. But of course, the engineer is caught between a rock and a hard place. I'm a contractor's man, by the way, guys, so I've got no sympathy whatsoever in this context. If you're paid to do a job, you should do a job. But it's human nature. If you know that, in fact, unfortunately, and it probably will be, it almost inevitably won't be clear cut, the employer himself, as we all know, the design is never frozen on the project in the Middle East, never ever from the start. I mean, we were talking about this yesterday, you know, the pressures of financial pressures and so on, but I've yet to see a project that has a frozen design at the beginning. Yet, if you want to adopt a lump sum fixed price job, that's what should happen. You should have clarity. You know, this doesn't happen. So I can empathize with the engineer, but of course that doesn't help the situation. And that just creates an adversarial approach, both by the contractor and by the employer. And I know we're not talking about this, but it's something that's been discussed over this week, and it's something I've actually begun to change my own mind to, is the potentially the introduction of dispute adjudication boards to this region would be a very good thing. It would sort things out at the time, but as we all know, and the fundamental problem with that is they're not binding. Now, this is why the Housing Grants Regenerations Act, one of the major reasons it came about in the UK was two issues really. Was pay when paid issues, which was a major problem, but also adjudication. Now, I've spent most of my legal career here in the Middle East, the last 20 years. So and adjudication has been discussed from day one. When James R. Knowles was first here doing the circuits, he would come over regularly and talk about adjudication, which was great. And it's a thriving area back in the UK. And as somebody said earlier in the week, in fact, ironically, adjudication has effectively replaced arbitration in the UK. But unless it can be enforced by the courts, by statute, it's never going to kick in. Yeah, and that's what we need. And so whilst we know there's a certain big project that's been completed, albeit a year late, apparently littered with dabs throughout the whole project. It's going to be very interesting to see how that actually spins out. Because frankly, signing up for a dab at the end of a project after it's happened, in my opinion, what's the point? It's just another tier. I might as well go straight to arbitration. But again, you're tied to this because of the contracts. I think it defeats the object. But anyway, I was about to segue.
That might well be the kind of construction of the contracts, like not encouraging prospective time management, and actually like get your EOTs in, and we'll try and agree them at the time.
Yeah, and I mean to be fair, I think it's also to do with how this jurisdiction operates and the mentality of the players. I can remember, you're going to love this, Oliver. When I was first here and had hair, as a young junior lawyer who came over here. Thanks for the laugh. Excellent. We did have it. I came over in 2002, and the firm I was working for were very fortunate to have the instructions to redraft the entire suite of contracts from one of the most established developers in the region. A partner came over, very, very good partner, very technically capable partner, came over from the UK to help me do this. He sat on many different committees and was actually instrumental with adjudication coming to the forefront in the UK. We drafted a brand new set of contracts for them. I remember the first meeting we had with the head of contracts, this developer, and he said, guys, lovely job, 8 out of 10, but 2 lost for adjudication. Why on earth would we want a system whereby the contractor can prepare his claim, take as long as he wants, and then suddenly I've only got 28 days to actually put my case forward. The adjudicator makes a decision, and then it's enforced and I have to pay. Why on earth would I want that? Get rid of it. And frankly, guys, I don't think anything has changed. Anyway, I am segueing now, and we're segueing into concurrent delay. So, Oliver, over to you.
So carrying on. Concurrent delay can be used as a reason to push back on an extension of time. It's usually the first offence, actually, really, to ensure that liquidated damages can be applied. Again, classic delaying tactic. So what happens then? What's this? You're really in a dilemma, really, as a contractor. Do you continue? Do you accelerate your works? Frankly, you're never going to catch up. That's the issue. Do you suspend? Well, you've got to be mindful of the contract. Quite often, it would be a breach. Or do you abandon the flight? Well, that's nuclear. That's almost definitely a breach of contract. And at the end of the day, really, during the lifetime of the project, liquidated damages aren't going to be applied by the employer. They'll kick it down the road.
I mean, that's the setup, isn't it, Oliver?
Yeah.
As much doom and gloom as it is, if the employer himself goes nuclear and starts applying LDs on interim payment certificates, with the best will in the world, the project is going to grind to a halt. The supply chain is going to be ruined because they simply can't pay their staff, and it's game over. So there is a balance there to a degree, but yeah, it's always unfortunately putting the pressure on the contractor.
Exactly right.
Yeah. Mm. So
Sorry, I haven't been doing the slides.
It's okay. So a question to you, Oliver. What is concurrent delay and why does it matter?
Well, I mean, in reality, it's very complex and sort of steeped in controversy over the years. It's not black and white, and it's applied differently in different jurisdictions. Simply speaking, concurrent delay is when two or more delay events occur at the same time, one an employer event, one a contractor event. However, as I'm sure we all know, it doesn't really operate like that. It's not as simple as it sounds. Under UAE law, there's no statutory rules expressly dealing with delay or concurrent delay, or the allocation of risk and responsibility in the event of concurrent delay. So it's necessary to kind of look at the common law, the English law, and how they deal with it, and also the SCL, obviously, protocol, because they're the seminal authorities on concurrent delay. We will still look at a few civil code articles,
yes,
that may be relevant, but you know, there have been a number of different approaches taken by the judges in the English courts, and I think it's important that we have a look at those.
Okay, so probably first off, what I'll do is I'll just set out the definitions of true concurrency under the SCL. That's Society of Construction Law Protocol, and a rather helpful definition of Keating. So the SCL definition is based on a narrow approach of true concurrency. I think that's up on the slide there. Okay, I'll just read that out for you. True concurrent delay is the occurrence of two or more delay events at the same time. One, an employer risk event, and the other, a contractor risk event, and the effects of which are felt at the same time, i.e. they start and finish at the same time. In contrast, a more common usage, which is that of the concurrent effect of sequential delays, where two or more delay events arise at different times, but the effects are felt at the same time. Okay, moving on to Keating. Concurrent delay is a period of project overrun which is caused by two or more effective causes of delay, which are of approximate equal causative potency. In both cases, the concurrent delays must lead to a delay in completion, i.e. they must be critical. But how exacting is of equal causative potency measured, and can it exist? Does it not generally become clear on the facts that one delay event is more dominant than the other? And should this be taken into account? Oliver, if you could now go through the three approaches, that would be helpful.
Yeah, I mean, the standard position on causation is the sort of but-for test. So you'd ask whether the contractor's harm would have occurred in any event without, that is, but for the employer's delay event. If you take an example, and I think this is something that was brought in by this SCL protocol, is if a contractor was critically delayed by 5 weeks, sorry, for a culpable delay, i.e. of his making, but in the middle there was a 2-week delay with an employer relevant delay event. Under the but-for test, the employer event is essentially irrelevant, and the contractor is still liable and therefore gets no EOT or costs.
But is this applied in practice to concurrent delay, and is there another way?
Yeah, I mean, this slide.
No, I mean, I'll jump in there actually in terms of the leading case.
Yeah.
Actually, sorry, that's probably jumped forward a bit too far.
Yeah.
The leading case on this is actually an English court case, which was well known as Malmaison, which basically says, hold on a minute, there's an act of prevention occurring because of the employer's relevant critical delay event, and the employer shouldn't benefit from that delay event that he caused. So this is the prevention principle, essentially. And it really should be more fair and reasonable than that. And therefore, you're kind of relaxing the but-for test. Because if the concurrent delay is there, the contractor can never really show that he would have completed on time but for the employer's delay.
I mean, the way I look at that is like the construction of the contract I mean, I'm not a lawyer, but the construction of the contract is there for the benefit of the employer. Like, so the whole liquidated damages clause is actually there to say, you can change your mind. You can do what you want with this building. You can put in a swimming pool on the 24th floor if you want to, but it's going to cost you, if we do that, we're not going to give you any penalties or liquidated damages associated with it. So it's quite important from that perspective that there's a sort of element of fairness that says, just because the contractor has been delayed for 5 weeks, if the employer does come in and actually decide to make some variations somewhere along the line, it's only fair that they shouldn't be penalised for it.
Do you want to bring up the slide?
Yeah.
I mean,
so this is kind of the position that the SCL protocol take. So within the SCL protocol, that they actually list out a specific scenario which is related to this 5 weeks of delay. And in essence, it's the relaxation of the but-for test. So it really does strongly align with Malmaison and that approach, and that's where it comes from. It's been quite interesting actually going through the case law related to the SCL protocol and actually understanding, oh, that comes from that case law, that comes from that case law throughout this process. But the most important part is that the two events are just simply overlapping. So it doesn't matter when the actual event started. It's more to do with when they overlap and actually are felt on the job, on the project.
Okay, question for you, Oliver. What about case of true concurrency? Is there any application and is it effective?
I mean, as I think we've said before, I mean, true concurrency is very narrow, where two critical delay events must start and finish at the same time and have the same causative potency or effective potency. I mean, it's very difficult, if not impossible, to show. One delay is likely to be more dominant than the other. So really, as far as I'm concerned, true concurrency is really a myth.
I think that's the approach that certainly I've found with arbitrators here in the UAE, and again, applying common sense. There really usually is and always is one dominant delay.
Absolutely.
Don't know, that's the way you'll vote, guys. Yeah, truth or myth, but that's the way I see it. Usually 9 times out of 10, there will be a dominant delay.
Yeah, and if that is the case, you know, if there is no concurrent delay, and should it be the case that the contractor caused that dominant delay, well, then the employer would be entitled to liquidated damages. Yeah. Obviously, conversely, if the employer had caused the dominant delay, then the contractor would be entitled to an EOT and costs.
Question for you, Paul, actually, is there a case for apportioning the respective concurrent delay events, do you think?
So if we go up to our friends in Scotland, you can't really discuss concurrency without discussing City Inn versus Shepherd Construction. And that they have a slightly different legal system to the UK. I was corrected during the course of this by Paul, saying that it's not a civil law system, it's actually a civil and common law system jointly, but I think there's a lot more codifying in Scotland than there is in England. So the way that City Inn treats this, I think I've actually got a slide for City Inn. This is the scenario that we have for City Inn. So what was happening was that there were two predominant non-excusable delays that were occurring. So this is a project back in 1999. It's a 168-room hotel, and the lifts were heavily delayed past the completion date, and so were the balustrades on the balconies. Now the employer came along and then made several instructions, kind of something quite minor like bedhead lighting, but they still require electricians to come in and do some finishing work. We've got like an atrium beam encasement, which required the contractor to come in and put some scaffolding up in the main atrium and actually make some modifications. We had things like trouser presses, final fix for the en-suites. All of these were requiring MEP trades. And then just it's more to do with finishing more than anything else. And then there's a cooling system and the refuge system. Now that last, what actually happened in fact was that they gave practical completion on the 29th of March. but there were still the works for the balustrades outstanding, and there were still some of the variations. So the cooling system for the refuge room was also outstanding. So in that instance, you had quite a simple scenario where you've got two parallel delays happening, and the way that they look at it, the way that the judge looked at it was he looked at the what's known as apportionment. So he looked at how important those delays were, and basically said, based on my decision about how important something is, I can see there's a critical delay there. So he gave an EOT, a full EOT to the practical completion date, because the contractor would not have finished his works, because these were considered to be the delays. Like, they could not have finished the job without having finished these variations. So it's only fair for him to be instructed. And the two delays were carried out in parallel. So there was an apportionment there between the two. And this fits quite well in with the situation in the UAE to a certain extent. In terms of the other case law around this, there's a very important decision also that supports this, which is another case in Scotland, the John Doyle case. Now, the John Doyle case is usually actually referred to in terms of disruption, where you're trying to understand that you shouldn't be putting forward a global claim and it should be particularized. But the point about that case was it really brought up the idea that you need to provide a causal link between the events and the cost directly related to those events. So if you can say that you've been delayed for a certain reason and you have costs stemming from that, then you can still claim the prolongation cost related to that particular part of the works. It's not treated as an EOT in a strict EOT where there's no concurrency, and because there's no need to, you just claim for everything, all the time related costs, all the insurance, bonds, etc., etc. But in this case, you can certainly have a look at dissecting the prolongation costs that are related to the particular elements.
I think maybe a question for you again, Paul, is do you feel that the legal approaches we have considered reflect what actually happens on site and the analysis undertaken?
So, yes and no. I mean, from a practical point of view, concurrent delays, as we said before, when you've got a simple, at the start of the project, there's less activities happening. So you've got things like access delays that may be occurring at the same time as mobilization. So that's where you get your true concurrency. And that's actually an example, I think, cited in the SEL protocol. But as you build in complexity through the job, the interactions between activities become more and more obvious, and the work becomes more and more detailed. Now, taking this example here, you've got two unrelated buildings that actually have, the example that we've got here is we've got the groundworks piling. There's obviously a problem in the ground that they couldn't claim for. And so the piling, the groundworks took longer than it should have. The other building, on the other hand, had an excusable delay on it. But the thing is, because the delay had already occurred in the groundworks and the piling, it wouldn't be obvious that you should get an extension of time for the whole project because it's only affecting building one, the variation. But in this case, that's what actually happens. You do get the SEL protocol approach would suggest that you would. Now, this assumes that these activities aren't related. But if this variation that happened in building one was actually quite a large variation, it might well divert manpower from building one to building two. So there could well be an extension of time claim based around the fact that, yeah, you've got obvious non-excusable delay during that period, but is that delay excusable because of the other event? And is it actually related to the manpower? So in that case, you might even do something like a productivity analysis to understand how many men you've got on the site, how your productivity may have been affected, and actually were your production levels available or not. So that's kind of like the one scenario. The other thing is when you start to move into areas like where MEP and ID works are being carried out at the same time, what actually happens is that you tend to, if there's a variation in, say, the MEP, the rate of the ID works is affected because of the MEP works happening at the same time. So you've got that interrelation where really you can't progress both activities as well as you'd expect because they're so interrelated. So that's where the real problems can actually happen. And in those, that's strictly concurrent delay, but really it's kind of very intertangled. I just want to briefly talk as well about the idea of pacing. Now, pacing is potentially like, this is the same buildings, or another example of two buildings, where you've got a variation up front. So it drives the completion date of building 2. And then the contractor comes in and says, well, actually, I'm not going to build building 1 at the same pace as I was going to build building 2, because I've now got that period of about 2 months or 3 months here, because we were doing all this variation work. I'm not going to employ any more resources, so there is a diversion of the resources onto this large variation. And it looks like you may have non-excusable delays to building 1, but it really is very much common sense for the contractor to take the position that, well, I'm going to slow down the works in building 1. The only issue with that is that you actually have to notify the employer, because if you don't, then you run into problems. And the big, I mean, Paul, we've had so many discussions this week about pacing.
Yeah. No, absolutely. I mean, I've got to say, I'm not a massive fan of it, to be fair. I think it's usually a convenient argument that a contractor comes up with after the event. I've never seen a contractor, big or small, actually personally put pen to paper and write to the engineer and say he's going to do that. And I'd love to know what the response would be. I mean, it would be very negative, in my opinion. The engineer wouldn't allow him to do it. It makes sense, but in reality, as I said, I haven't seen it, and I think it's where contractors retrospectively allege that they have actually paced their works, I think, frankly, in my opinion, it lacks credibility. And certainly in an arbitration, I just don't think it would hold much water, to be fair. But on the flip side, if it was actually done as you say it would, in practice as in theory, I'd be all for it. But in reality, I've never seen it. So that's why I'm a bit cynical of it. It's in principle absolutely correct.
There can be kind of like technical principles, I think, like where you might have something. For example, you might not want to engage a testing and commissioning engineer on a job. So if you finish the works early on building 1, it doesn't really make much sense to engage a testing and commissioning engineer to do that work earlier. It's going to cost you more money for 1. So there are practical reasons. You might not notify the client, but it becomes fairly obvious through the expert evidence.
Yeah. Now I'm alive to time, people. I know that we're getting close to time, so I think I'll move on. I'll whiz through the brief section on the UAE law. Then we can move on to our conclusion and tips and the vote. So just very briefly, whilst there's no specific section of the Civil Code dealing with concurrency, there are articles of the Civil Code which are helpful in principle in building viable arguments to progress and defeat principles of concurrency raised by the employer and the apportionment of costs. Now, as we see, there's the articles put up there, just briefly going through those. Where the contract works have not been completed pursuant to the time of completion of the contract, a contractor is by default liable for liquidated damages. However, in order to assess the extent of liquidated damages applicable to the contractor, Article 878 becomes vital. Article 878 states that a contractor shall only be held liable for loss or damages insofar as it has caused such damage. Therefore, a possible interpretation is that the contractor may not be held liable for employer delay. Equally, Article 290 provides that a judge or arbitrator may take into account the level of involvement of the other party when assessing compensation. Furthermore, Article 291 may permit again a judge or an arbitrator to apportion liability for concurrent delay. Therefore, when Articles 290 and 291 and 878 are read in accordance with Article 390, one could argue that a judge or arbitrator may amend and reduce the liquidated damages provisions in the contract if it finds the employer is culpable for concurrent delay. Of course, conversely, an employer can rely upon these same provisions insofar as a contractor may be claiming an extension of time or prolongation costs during a period of concurrent delay. Furthermore, Article 247 provides that the party may refrain from adhering to its contractual obligations in the event the other party's non-conformance. Other arguments that I'm sure you've all heard before and are frequently used in this region fall under the articles of 246, 106 and 318, which place a duty of good faith on the parties, prohibit the unlawful exercise of a right, together with the principle that the party should not be unjustly enriched, respectively. So whizzing through those, in conclusion, I'd like to ask you, Oliver, what tends to be the preferred approach?
Okay, well, from arbitrations we've experienced, the actual tribunal tends to be on sort of complex, high-value construction claims. They tend to be made up of at least one sort of Western practitioner, a construction casey, barrister.
Yeah.
So they will look to apply the UK principles that we've discussed earlier, whether that's consciously or subconsciously. But at the same time, they'll be probably looking to find a dominant delay in order that they can award an extension of time. Maybe not cost, but
so matters are cleaner, to be fair. I mean, you know, concurrent delay really is predominantly it's to the employer's benefit, isn't it? I mean, the contractor, ideally, he wants extension of time with his prolongation cost. The employer wants to apply liquidated damages.
Yeah.
So
if there are valid grounds, they'll look to sort of see if there's a dominant delay.
Yep.
Yeah, but before you get to the sort of arbitration, I mean, if an employer is being stubborn, holding his ground and sort of saying that your delay is not there, it doesn't exist, and actually it's the, you know, knowing full well actually it probably is the employer that's actually culpable. But you know, before you get to arbitration, you might want to think about what we probably informally call the Majlis approach, which is, you know, shaking hands on an extension of time with no costs. And that's something that happens quite a bit out there.
I think also, Paul, you had, when we've been discussing this, I mean, you had an issue, quite a pragmatic approach that irrespective of whether the contract actually states that the concurrency analysis should be carried out, a contractor should think carefully of doing that.
Yeah, I mean, certainly in our consultancy, we've actually put forward concurrency arguments on behalf of the contractor. So we've seen things like a contract constructed to say the contractor needs to put forward a time impact analysis. And then the engineer, on the other hand, will consider concurrency needs to consider concurrency. So if that's the case, you want to try and provide the arguments that the engineer can adopt for the concurrency arguments. So you're trying to whittle away the amount of concurrency, obviously, from a contract.
Preempted almost.
Yeah, preempt the arguments. And it really puts you in a much stronger position, potentially.
Okay. Right then, so our final scenario. Tips. Oliver, what would you like to put to the audience as the way forward?
I would say be wary of the contract terms. I mean, we've seen it more and more frequently used that there's an exclusion of an EOT in costs if there's any concurrency. So, yeah, you know, you've got to be careful that the UAE law does say that when the wording of the contract's clear, then you can't deviate from it. You know, and you don't want to live on the chance that concurrency is a myth. It's a risk. So just be careful of that, and maybe get lawyers on board early when the contract's being drafted, you know, so that they can advise on that sort of thing.
Yeah, no, absolutely. I mean, I think it's vitally important. I'm obviously not just self-promoting, but I think whether it's in-house, of course I am, whether it's in-house or external, it's vitally important that you do have lawyers review your contracts, experienced contracts and construction lawyers. You know, you're at the honeymoon period at the beginning. Nobody wants to rock the boat. I mean, I can speak firsthand, in particular from my time of being an in-house lawyer for a very large international contractor. On a regular basis, I would receive the contracts review. The most time I was ever given was 2 days. They didn't want to give it to me. Oh, no, it'll be all right. You know, so what you used to do, some people call it the traffic light approach. I call it the bloody minded approach, quite frankly. You'd list out, there would be a plethora of issues you would have, but you would break them down into deal breakers, things that could be negotiated, things to go. I was lucky if you got even 3 clauses that my company were prepared to argue. And it was always a nightmare. Luckily, we always used to dig our heels in on the disputes clause. And I had one time where a concurrency was actually raised, and my company put their foot down and did not sign up to it. But of course, it came back in with the classic infamous amendment, number 4, later on in the project, where there was less leverage to negotiate. I would also say, I am predominantly a contractor, subcontractor man. My clients that do well with the disputes are the clients that do have an experienced contracts commercial department. They do invest, actually, and Paul's going to come on to this, but it's a pet peeve of mine. They do invest in an experienced planning department. But I mean, you can't get away from the fact that these, all contractors and subcontractors are overworked and overwhelmed. Having a team of project counsel on board that can maybe just come along once a month just to review things, do a sanity check, is absolutely invaluable, because unfortunately, in a lot of projects, as we know, you are going to end up in dispute, either formally or informally, and records are king. And I'll come back to the old adage, for notices. If rainforests have to be cut down, they have to be, but you've got to comply with the contract. If you've signed up to that contract, you've got the easiest way to avoid being in breach or, God forbid, having a claim dismissed is to actually comply with those notes. And it's not difficult to do. Yes, you don't want to upset your relationship, but is that relationship worth $500,000? No, it's not. Yeah, and it will soon be applied at the end of the job. That special relationship won't exist. Potentially that project director from the employer, he won't exist anymore. And suddenly in the cold light of day, I can see some faces, we've all been there, cold light, but he's my friend. Of course he is, but he's not there sitting being cross-examined, is he? And he's not the one that didn't write the notices. And suddenly it's your proverbial head on the block when you realize for the 5th time you've done it, where did it all go wrong? Just setting up these simple procedures, I think, is invaluable.
And the best thing about Primavera is you don't have to chop down any rainforests.
Yeah, exactly. It's very eco-friendly. Yeah. Sorry, I'm done.
You just need to submit the electronic copies. But one thing I will say about baselines and what have you, baselines, typically they can be very complicated. You've got to really think about how they're going to be maintained during the course of the project. So I've seen somebody aiming at a 30,000 line program, 70,000 line program. It takes an army of planners on a job to maintain that program. So simplicity is key. I think Einstein said something along the lines of make it as simple as possible, but not too simple. But that was definitely wrong.
Made sense then. Made sense. Yeah.
But really, it really helps having health checks throughout the project for your planners, and actually look after the planners, because they typically can be stuck in a room somewhere, and nobody will talk to them. They're just on a keyboard. But
you've got to remember, they're planning your project. They're planning the success of your project.
And the way that they can actually make update programs make much more sense and real on the job is actually a really important aspect of this. The amount of times where I see update programs thrown in the drawer, and then an expert will come along and say, okay, well, we'll just take the progress percentages. And it just loses that real element of reality to understand, this is the thoughts of the project at the time and how we were actually doing that, and why we made decisions. So that linkage of why you're making decisions at the time has to come from the project management team. So the planner and the project management.
Yeah, they've got to interact. And I think my final thought is hope is not a plan. If your project is going the wrong way, it's not going to suddenly miraculously get better. It's going to get worse. And I've seen this time and time again, certainly from the project manager's perspective, super keen to get the job done, we can do it kind of attitude. But frankly, from my opinion, you should plan for the worst and hope for the best. And that's really the way forward. I think, Oliver, you just wanted to maybe add a final comment.
Well, same thing that we've talked about before.
Segues back in, doesn't it?
Yeah, it does.
It does segue back in. It's records again.
I want to leave you with this. All we have to decide is what to do with the time that is given to us. Gandalf from Lord of the Rings.
He did it. So, congratulations. Yes, you did get a Lord of the Rings quote in. Thank God. We'll be talking about that afterwards, quite animatedly. Right. Any questions, people? We'd be happy to answer.
Yeah, I have some comments. The discussion in general. First, at the beginning, we discussed approach, the different approach to for the determination of concurrent delay or the extension of time at the beginning.
Yep.
So I don't. While I believe that determining the concurrent delay retrospectively will be more real and practical in terms of compensation of cost. But the contractor, it's unfair just to wait till the end of the project, because the contractor will need to make informed decisions on the delays, timely decisions. So we need to reach a balanced approach. How can we take decisions for the contractors, EOTs, on time, but at the same time, not to put burdens on the employer to pay compensation?
No, absolutely, yeah. No, and I think that's a very, very good question. I mean, I think this is how and I'm sure, Peter, you could chime in if I get this wrong, but I think it's one of the reasons it's been addressed by FIDIC over the years. I mean, and it's always been a pet hate of mine. FIDIC 4, which is still the most commonly used form of contract. Yes, there are time periods for the contractor to issue his notice and to provide his full and detailed particulars, but there's no counter condition or obligation on the employer. Now that has actually changed in FIDIC 99. There is a process now where the engineer does have to come back by a certain time and give his analysis, and that I think needs to come in. But of course, it's when these contracts are reviewed and adopted, and let's be fair, it's the employer that drafts these contracts. A lot of these conditions that came in FIDIC 99 and in FIDIC 2017, which was there to balance out the obligations and so forth, have been removed, unfortunately.
Yeah, but in FIDIC 4, for example, if the engineer will not come back after.
Sorry, say that again. Sorry.
In FIDIC 4,
yeah,
the contract is silent if the engineer, for example, will not come back on time.
I know it's unfair. It's wrong.
Yeah.
I'm totally wrong. Yeah. So he can wait to the end, and in fact, what all that does is actually force the contractor into actually triggering a dispute and requesting an engineer's decision under clause 67. So it actually escalates the matter. So it doesn't help any of the parties. I totally agree. Yeah. Absolutely. Yeah.
The second point for when all discussions about concurrency either are oversimplified or they are overcomplicated. Yeah. In reality, we have certain practical issues when we determine concurrency. For example, the very common issue of convergence and divergence in the critical path. We assume, even the exhibits we presented now, we assume that concurrent delays are isolated, which does not happen. For example, sometimes you have two competing causes of delay, which will meet at a certain point of time, and this will be the point where the expert needs to interfere. At the same time, we have, for example, one delay event which will divert at a certain point of time to more than one path. So the issue is there. Concurrent delay is real, but it's not oversimplified, for example, as presented in the SCL protocol and so on. But also it's not overcomplicated as some approach are trying to present it. Those are the 2 points I wanted to make.
Okay. I mean, one of the considerations that I think from a delay perspective is that there's a certain quality of a program that you've got to work with. So there's a margin of error that goes with any delay analysis, and whether that margin of error is a day or 3 days or a week, possibly more, is quite key to understanding how you actually deal with concurrency. So there has to be some kind of consideration put to actually what are we dealing with here? Like, are we dealing with a really, really badly put together program? And in that case, that's where it opens the door for concurrency a lot more, because really the employer is just simply going to say, well, of course it's concurrent. You didn't have the issues aren't particularly specific. So yeah, there's certainly an element of that.
I mean, I think when there is concurrency, and we touched on this a bit about apportionment. You know, in theory, it's great. It sounds like a great idea. It's quite difficult to put in practice, though, right? You say probably that it can be done.
Yeah.
But it takes excellent records to show all the costs incurred and everything else.
Yeah, and a lot of conversations with people and understanding what's actually happening on the job. Is that perspective of actually what was in the minds of the people at the time?
But maybe there is a move towards that.
Sometimes also we decide this on it says, for example, the program update, but at the end of the project, when the expert will come during arbitration, we will identify a completely different critical path. So the parties decided something during the course of the project based on what they believe to be the critical path at the time. But in reality, the expert come with something else completely different from what they decided based on.
I mean, really, that kind of thing should be informing an expert as to what is critical. Like from my perspective, I would certainly look at program updates to understand it. You get an impression of what's potentially critical from update programs, and that kind of guides you towards the final analysis. And it is quite possible, actually, to think for a site team to think something is absolutely critical, only for events to overtake it that have overridden it, and then actually something is completely different and critical. So it's understanding that perspective, and that's where the importance of a decent expert comes in, I think.
Yeah, and at least in planning team during the course of the project.
Absolutely, yeah. Absolutely.
Some planning engineers are tending to overcomplicate everything just to show that.
Yeah, it's like saying like 30,000 line activity, like programs. It's crazy. It doesn't help anyone.
Chris, did you have a question or comment?
Yeah, well, comment. What we should never forget in all of this is that for a delay to attract either damages or extension of time, it has to be on the critical path.
Absolutely. Yeah.
And concurrency, as defined in Malmaison and supported by the SCL, doesn't really address that, because it says that we can have a smaller delay in a period of existing delay. But we're not going to take any, we're not going to take any notice of that because it's not actually on the critical path. That is the hard line of first-in-time analysis. True concurrency, that's where you have both activities of equal potency, of equal length, starting and finishing at the same time, and in effect, both on the critical path. Now, this is amended in the Royal Brompton case, which gives where it starts and whether it extends over the critical over the parallel delay period. And then we get to City In. City In is of no consequence in English law. It's apportionment, it just doesn't happen. And then there's been various cases developed over time, but we always come back to the Malmaison. And you have to have a delay that actually affects the critical path. And the prevention principle sort of supports the Malmaison approach, that actually the smaller parallel delay did have no effect on the completion. And it wasn't actually preventing the contractor from completing because he had an existing delay of greater potency and greater length.
The question is, it's greater length, but I don't know if it's greater potency.
Yeah. Potency is irrelevant if it's not, if it's of minor length, yeah.
If it's another planning question, I'm going to stop you. Right, go on then, Andrew. Right. I want to get stuck in a lift for these guys.
Thanks. I wanted to make a suggestion, if I may, but before I did, I just wanted to say, I hesitate to say this, the way the three of you have packaged this discussion today, you've almost breathed new life into concurrency.
Checks in the post.
Yeah. Good lad. And I didn't want you to do that either.
No, you did. No, I must have hurt. Yeah.
Okay, the suggestion, in keeping with the way that I know at least two of you on the panel like to play random keyword bingo in your presentations, I'd like to adopt contractual provisions where there are rules on what can and can't be said. I think we should ban on contractors' parts any references to the SCL protocol, particularly the first edition. And on the other side, I think we should ban any references from the engineer to concurrency. And I think the GCC would be a much better place if we did that.
I'm not going to argue. Yeah, no, yeah, I think I agree. Yeah, I never thought I'd say that either, Andrew. Yeah, no, right. Yeah, sure.
Comment about someone from expert panel says that the delay, sometimes the engineer or the consultant itself, he is the one who caused the delay. However, the consultant is not liable to any party for any compensation.
I know life's unfair, isn't it?
It's not fair.
It's very unfair.
I attended one case recently in Dubai court that.
Well, the employer, he's the employer's agent, so in fact, unfortunately, the employer is liable for him. But then what happens is, of course, potentially the employer could sue the engineer for negligence under the consulting. It's never going to happen.
Never happen.
Never going to happen. No.
This recent case that the Dubai court first instance said that the engineer is liable for compensation towards the contractor.
Right.
And they obliged him to pay around 1.5 million to the contractor. But unfortunately, in the Dubai Court of Appeal, they dismiss this one, and they said that, however, he should work impartially. And
that's very interesting. Actually, hopefully, that's the way things are going to go. It might make people think. Or potentially they'll be more independent. That's what there's an argument there. I'm afraid, at the end of the day, can somebody be independent when their fees are being paid by the employer? It's a very difficult balance. Well, no, you can't apply it to lawyers because we're legal representatives. We're partisan.
I mean, what would that mean? That would mean a contract being made between the engineer and the contractor, which is not going to happen, is it? Really? So.
Peter?
Paul, I'm the awkward squad, I'm afraid.
Yeah.
You said at the beginning, when you put the concurrency argument to the floor, was it myth or was it reality?
So the vote. Yes,
you were going to see if we changed our minds.
Sorry, I was just waiting for the question. Sorry, I was waiting for the question. Okay, well, thank you very much, Pete. Okay, so the easiest way to do this then, hands up who thinks concurrency is a myth.
I still think so.
Okay, fair enough. Okay, right.
We did try.
Can I explain myself?
Of course, Peter. Yeah, go.
If we were sitting in London, I might have voted the opposite way. But because we're sitting in this jurisdiction, I think the safest thing for your delay expert is to use an apportionment basis, because there is no judicial support or judicial understanding of concurrency in this jurisdiction. So I would always recommend using an apportionment method, a la the Scottish case that was mentioned.
Okay.
By the way, the experts shall not vote for this, because if it is a mess, so we lost like 90%.
That is a very good point. Yeah, exactly. And so that was a myth. And who believes that concurrency is truth, exists? Concurrency exists.
That's why we exist.
Okay, there we go. Okay. Well, thank you very much, everybody. We'll be available outside for questions.